Trade is an exchange of goods and services between two parties that are localized in different countries. So there is no additional value in trade. You have to provide a product or a service and you get the money. So there is no additional value. The economist said that trade is a kind of monetarization. You provide something and you get the money. So trade also is a very short operation. You provide the product or the service and you are paid. For example, we have a company in France that export products or services, computers, to a company here in Tanzania. The company in Tanzania pay, and that's finished. Investment requires establishment and movement of persons. Investment is a territorial activity. It requires establishment of the economic actor in the territory of the host state. And investment is a long-term operation. It's not a short-term operation like trade. There is in investment an adding value because investment produces income, produces benefit. So the two operations are different from an economic point of view. To give you an example to illustrate an investment operation, we can think about a European company that come from Europe to build and operates a solar power plant here in Tanzania for 24 years. So the two operations are totally different. This presentation will focus on investment. So, second question to understand the context, what are the sources of investment law? If we have an investment, what are the rules that could govern this operation? Investment law includes three legal sources. We have international law, especially investment treaties or investment agreement. We have also the investment contract, because sometimes the investment requires a contract concluded between the government and the investor. That's the second source. The third one, we have in many countries domestic laws, that's what we call investment codes. The investment codes provides for some rules applicable to the investment. So we have three sources, and here we will focus on the international law source. That means we will focus on investment treaty. To be clear on the issue, what is the definition of an investment treaty? In general, we have many investment treaties, more than 3,000 investment treaties that are concluded, and it's very important that we share the same definition, the same notion, in order to progress. So, what is the definition? Normally, I will ask someone to answer, normally. But I will give you the definition in order to move on. There are two elements that are required to understand, to identify an investment treaties. First, the parties. Investment treaty is concluded between two states. State to state. That's the first element. It's an international agreement concluded between two states. Contracts are concluded between the state and the investor. Investment treaty is concluded between two states. That's what we call the formal element. Then the second element is the objective, the purpose. Investment treaties protects investment made by an investor from one state when this investor invests in another state. To be clear, if you have an investment treaty between France and Kenya, that means that Kenyan investors, when they invest in France, are protected by this treaty, and this means that when French investors invest in Kenya, they are protected by the investment treaty. We have many kinds of investment treaties. We have bilateral investment treaty, BIT. We have regional investment treaties, like the Arab Investment Agreement, the Islamic Investment Agreement, the COMISA Investment Agreement, and we have multilateral investment agreement. All of them, we call them international investment agreements. So we understand the notion of investment treaty. Now, what is the structure of an investment treaty? What do you find in any investment treaty? Investment treaties, they have the same structure. They have the same contents. Normally, I will ask you to find this treaty, the bilateral investment treaty between Tanzania and United Kingdom. Use your computer to find this treaty. Use your mobile. In order to consult Facebook, I know that some of you are now looking for Facebook, LinkedIn. Some of you are learning or newspaper. No, please find this treaty. Find the bilateral investment treaty between Tanzania and UK. And give me, what is the structure? Look at it very quickly. You will find, just read the title of the treaty. And you will find the structure. It's the structure that we find in any investment treaty. We find the same rules. Sometimes there are differences, but finally we have the same content. I will make issue sample for you. In each investment treaty, we find two big chapters. We find the title, then you have a preamble, then we have two kinds of provision. We have provision related to the scope of the treaty. Then we have provision related to the protection. For the scope, we have 4 conditions. Who are the investor? The definition of the investor. What is the investment? Territorial definition, the territory, how to determine the territory, then the time. So we have the investor, the investment, the territory, and the time. If the 4 conditions are met, if you are an investor within the meaning of the treaty, making an investment within the meaning of the treaty, in the territory of the state within the meaning of the treaty, and if the treaty is into force, you are protected. And then you have to move to the second chapter. What is the protection that you can ask for? We have two kinds of protections. Substantial protections. The state must give you the fair and equitable treatment, non-discrimination, compensation in the event of expropriation. We have many rights. Then we have also another important right, arbitration. You have the possibility to initiate directly an arbitration against the state if the state did not give you the protection that is mentioned in the treaty. So this is the structure and the philosophy of every investment treaty. If you demonstrate that you are an investor, that you have an investment, that this investment is made in the territory of the host state, and the treaty is into force, you are protected. You can ask the state to give you the rights, and you have a list of rights. Then if the state did not give you the rights, you can enforce the protection by using the arbitration offer, by using the arbitration clause provided under the treaty. So it's a fabulous system of protection. Now, let's move to the African protocol. Just, I ask you to see the treaty, Tanzania, UK, and the African protocol from formal point of view. How many pages in the Tanzania UK treaty? How many pages for the protocol? No, more. Look at the African Investment Protocol. So for the UK, Tanzania, we have a short treaty. But for the African Protocol, we have a lot of pages. We should take this into consideration, don't forget that. So to move quickly, this protocol was concluded on February 2023 within the context of the African Continental Free Trade Agreement. Normally, it reflects the common African position on investment and is not yet into force. We need 22 ratification. And when we have the 22 ratification, we have to wait 13 days, then this instrument will enter into force. So until now, this instrument is not into force. And I am not aware of any ratification by any states that signed this protocol. First question, what is the scope of this protocol? I will follow the same structure. Each treaty includes provision related to the scope and provision related to the protection. If you want to understand investment law, I will ask you just to read the African protocol and the treaty between Tanzania and UK and compare both of them. Some of you, they have a problem to sleep. I was told that some of you, they cannot sleep easily. I will give you the solution. Tonight, take the two treaties. Believe me, in 5 minutes, you will sleep. Okay, so the protocol is, the scope is to protect inter-African investment. That means that an investor from an African country that wants to invest in another African country is protected by this protocol. However, there are many investment treaties, bilateral or regional, between the African countries. What is the future or what is the legal statute of the bilateral investment treaties? We have 190 intra-African bilateral investment treaties. Some of them are in force, others are not in force. We have also many treaties, investment treaties between African countries and non-African countries, third countries, France, UK, China. Article 49 of the protocol requires that the member states must terminate their intra-African BITs. Okay. They have to terminate their African BITs. They have 5 years to do it. Then, for regional investment treaties, they must be terminated. So this protocol is supposed to be the only investment agreement between the African states. There is nothing on the investment made by non-African in African countries. It's a matter of relationships between Africans. An investor from Morocco that makes an investment in Cameroon, or an investment from Burkina Faso that makes an investment in Tanzania or in Kenya. Regarding the protected investors, the protocol provides that there are two kinds of protected investors. We have the natural persons and we have the corporations. The investor could be a natural person like me, like you, but could be a corporation. And what we find in the protocol is a limitation of the scope. We limit the scope, the personal scope. I give you an example. For the natural person, an investor must have the nationality of a state, members of the AFTA. However, they said that if the investor has two nationalities, two citizenship, he's not protected. He's not protected if he lives outside the region. For example, me, I am French and I am Tunisian also, but I live in France. That means that if I invest in Tunisia, I am not protected. Why? Because my residence is in France. My question is, why I am not protected? If I bring money and I create a job and I promote the development of the country, why you exclude my protection? What is this conception? What is important in investment is not what is the nationality of the investor, if it is dual national, or what is important is if he do good thing for the country. Now in the African protocol they said he's not protected. That's all. Investor could be a corporation, and the protocol requires a substantial business activity in addition to the incorporation for the company to be protected. If you look at the treaty between UK and Tanzania, and if you look at the definition of investor, who is the investor? For corporation, you will find that the definition of corporation is based only on a legal link and corporation. That means that a company incorporated in UK is protected if this company invests in Tanzania. No more, no additional requirement is necessary, just incorporation. So for investor, in order to be protected in Tanzania, they just incorporate company in UK and they are investors. The protocol said incorporation is not enough. To be protected, the company need to be incorporated in African country, but in addition to incorporation, the company needs to have a substantial business in the country of incorporation. Why require substantial business? If the company bring money for you, create a job, promote the development, why this company is excluded? Just I am asking a question. So what is important is that protection investors, there are requirements, additional requirement to what we find in the traditional investment treaties. They require more link with Africa. Second, protected investment. There is a debate in investment law. Some definitions of the investment are very broad. Some definitions are restricted. The protocol provides for a limited definition of investment. In order to have investment, there are some characteristics that must be demonstrated. Investment requires resources, capital, expectation of profits, certain duration, risk, then a significant contribution to the host state sustainable development. I am so sorry. It's very difficult for me as a lawyer to understand what is significant contribution to the host state sustainable development. So contribution is not enough. You have to provide, to mention, to demonstrate substantial. What is substantial? Not easy to understand. So contribution is not enough. You have to contribute, but significantly. It's very difficult. Then there are exclusion. Government debt securities are not investment. Portfolio investment are not investment. If you have only 10% in a company, if you are from Tunisia, you invest here in Tanzania, and you have only 10% of company, it's not enough. It's excluded. Contractual claims are excluded. Sale of goods and services is excluded, but it's not problematic because it's a trade, no investment. So we have a requirement, a lot of requirement to be protected as investor and for the investment. Now, what is the protection now? The protocol, according to its creators, the protocol illustrates a new generation of investment treaties. We have the old generation, and by this protocol, we are opening the new generation of investment treaties. In order to understand the philosophy of the protocol and to go quickly, I can propose two conclusions. First conclusion, the protocol provides a balanced approach to deal with the investment. That's what I will try to show you. Then, unfortunately, the practical impact of the protocol is very, very, very limited. The protocol has a limited impact, both on non-African investors and even if on African investors. So I will try to explore the two topics with you. Okay, balanced approach. So we try to find a good balance between the interest of the investor and the interest of the state. Because the old generation of investment treaties focuses only on the interest of the investor. They don't take into consideration the interest of the state. We decided within this protocol to take into consideration the interest of the state. How? By the clarification and the limitation of some provisions. For example, we remove the obligation of fair and equitable treatment, and we replace it by a new obligation, administrative and judicial treatment. We limit the obligation to provide protection and security. Investment treaties provide that the state has to give the investor protection and security. The state has to protect the investor and grant him security. The problem is, what kind of security? Is it legal security or physical security? There is a debate. The protocol said it's only physical security, not legal security. That's the first point. Second point, the protocol, in contrast to many investment treaties, including the intra-African investment treaties, provides a list of derogation, exception, to protect the interest of the state. We have a special exception and we have general exceptions, many exceptions. We have the right national treatment, then we have a list of exceptions. We have expropriation, then we have a list of special exceptions. Then we have a general exception, environment, labor, consumer protection, climate change, public health, development goals. Why do you protect the development goals? We know that in order to be an investor, you need to contribute significantly to the development. So we have also the development goal as exception. Then, third, the protocol provides for investor obligation. This is new. The investor must observe some obligation. They are listed in the protocol. He must observe national and international law, observe business ethics, human and labor standards, protect the environment, right of communities, refrain from interference with the host state internal affairs and intergovernmental relations, anti-corruption, taxation and transfer of pricing, no corruption. Sometimes you have the same exception many times. Third. Fourth, regarding the dispute settlement is the most important provision that we find in investment treaties. So, okay, we have many provisions. What's happened if those provisions, those obligations are not enforced? It's not from the point of view of the investor, but only from the point of view of the state. The protocol provides for many obligations that the investor must observe. If the investor did not observe the obligation that we find in the protocol, what's happened? There is no arbitration in the protocol. There is no dispute settlement mechanism in the protocol. It was very difficult to find an agreement on the dispute settlement. So, you know the African tradition, if there is no agreement, let's do it later. So they said, okay, we will start negotiation to determine the dispute settlement mechanism 12 months after the entry into force of the protocol. We don't know where the protocol will enter into force. So you have to wait 22 ratification, 30 days, then we have 1 year to determine what is the dispute settlement mechanism. No dispute settlement mechanism, no arbitration, a list of obligation, a list of exception, special and general exception without any control. Certainly, we can use the dispute settlement under the African Continental Trade Agreement. You can use it, but to use it, you need the intervention of your state, because I will show you tomorrow that the dispute settlement protocol is a state-to-state mechanism. So before this protocol, if the state did not observe the obligation, the investor can initiate an arbitration against it. Now, the investor cannot initiate arbitration against the state. To be honest with you, African investors, they don't like arbitration. We have a few investment cases between an African investor and an African country. We have 5 maximum or 6 between, for example, investor from Mauritius, 2 cases against Madagascar. I was the representative of Madagascar in this case before the exit. I represent at that time the state. In the 2 cases that I mentioned, 2 of them, they are cases between investors from Mauritius that initiate arbitration against Madagascar based on Mauritius-Madagascar investment treaty. And we have some other cases between investors from Tunisia against Gabon. So few cases. However, we should mention that the protocol, and this is the 5th dimension, include a new chapter on investment facilitation and promotion. However, all the obligations are subject to condition. The condition is they are subject to the respective laws and regulations. That means that the state protects you, but within the limit of its laws and regulation. We don't have any uniformization. The state, for example, as you see here, must facilitate and granting visa. That's good, but within its rules and regulation. So we don't have new obligation, just a reference to the state laws and regulation. We have also state parties are encouraged to establish a framework. What is framework? A framework for cooperation and coordination. What is the difference between cooperation and coordination? If we use 2 terms, that means that they have meaning. I don't understand what is the meaning. Cooperation and coordination between relevant and competent national regulatory authorities with a view to facilitating investment flows. Very difficult to understand what is required from a practical point of view. So law provision, legal provision, they need to have a meaning, clear meaning. We are not in literature here. We are not writing science poems. We need to be clear. We need to understand what is required. And we don't have a dispute settlement mechanism. So if there is a problem on the interpretation and the application, we cannot know what is the meaning of this provision. This is the protocol. According to its creators, the protocol aims to establish a new balanced approach. However, and unfortunately, the protocol, in my opinion, has a very limited practical impact. And that's what I will try to explain in the second part of my presentation. First, as I told you, this protocol the scope of the protocol is inter-African investment, and inter-African investment is very limited. Very, very limited. According to the African Development Bank, we have only few companies, few corporations from Africa that invest in Africa. I can give you the most African investors come from South Africa, 39%. Then Morocco, 11%. Nigeria, 9%, and 8% from Kenya. So the investors come from the 5 countries. Now, what's about the host country? The host country that attracts inter-African investment are Ethiopia, Ghana, Mozambique, and Nigeria. This country get about 44% of total African investment. Nigeria, 13%, because of the oil. Ghana, 12, Mozambique, 12, and Ethiopia, 7. So the African investment is between 10 countries and is nothing, very, very limited, very, very limited. So all this debate, or this protocol, is to protect a small, very small portion of investment between Africans. Do you think that Burkina Faso investors, they will come to Tanzania to invest? Not a lot. Most of the investors come from outside Africa, and they invest in Africa. So the protocol has a very limited practical scope. A lot of debate for nothing, for very limited practical impact. And the protocol did not affect the treaties concluded between African states and third non-African states. The treaty between UK and Tanzania is still into force. That means that if you want to be protected, it's better to incorporate a company in UK and you invest through this company in Africa. Let me give you an example. If you are an investor from Morocco, you want to invest in Tanzania, you will be submitted to the African Protocol. And the African Protocol provides for a list of exceptions. And there is no dispute settlement. If you are intelligent, you create a company in UK, you are protected, and you invoke the bilateral investment treaty between Tanzania and UK. You don't need the protocol. Why? Because the protocol is pro-state. No arbitration, nothing. By creating corporations and companies in third states and using the bilateral investment treaties concluded by African countries and third state, African investors are more protected. African investors could structure their continental investment through non-African companies to gain access to treaties giving them broader protection than the protocol. So if you want to promote African, at least you have to give African the same level of protection that we give to French, to English, to American. We are supposed to create a community together. How do we explain that you give the French investors, the American investors, more right than the African investors? Why? That's the promotion of African interest, community, all this political debate. When you see the practical impact, you will see that, yes, there is a limitation, but the limitation, fortunately, is less favorable for the African than the non-African. So if you are an African and you want to get a protection, it's better to create company outside Africa and you make your investment through this company. Then, this protocol is very strange because it's a kind of discrimination between African investors and non-African investors. African investors have less protection than the African. Non-African have more rights than the African. The non-African can use arbitration, but the African no. So the impact on African is very limited, and the African investor can avoid the protocol by incorporated company in third states. Then, for non-African, the protocol has no impact because the bilateral investment treaties between African and non-African are still into force. So you see what is the reality of this protocol. Difficult to understand, difficult to interpret. Then we discovered that, unfortunately, he discriminates Africans. If you want, he discriminates Africans, and investments from Africans is nothing. The protocol has a very, very limited impact. This brings us to the conclusion. Today, there is a debate on investment law, investment treaties. I agree that the first generation of investment treaties are pro-investors. They did not take into consideration the interest of the state. That's true. If you look at the treaty between UK and Tanzania, you will find only obligation that the state must observe, rights that the investor can claim. That's true. So we need to reform the system, but not to deform the system. Because what is strange is to move from a pro-investor treaty to a pro-state treaty. You need to find the balance. If you want to attract investment, if you want to promote development, you should recognize that the investor must be protected. And if a state, without any reason, expropriate the asset of the investor, the state must compensate. Sometimes the expropriation is based on interest, national interest, but you have to understand the point of view of the investor. The investor needs protection, and the interest of the state needs protection. You have to find the good, the objective balance. But in my opinion, it's very dangerous. It's very dangerous. The extremism is very dangerous. We should reform, taking into consideration the balance of the rights. Because what we are seeing here with this protocol, that we are moving from a pro-investor model to a pro-state model. Finally, with a discrimination against Africans investor, and finally, very, very limited impact. Because as I told you, the intra-African investors' investment is very, very, very limited. That is my conclusion. So, as you see, I am not here to describe this protocol. I am here to explain the protocol, but we need to think it a little bit to see what is the impact. Because sometimes the negotiator of some treaties, they are together in a closed room. They are not aware of the realities of the practice, and they produce instruments that are totally disconnected from the reality of the business, from the reality of investment operation. Unfortunately. So let's say it's a good contribution to understand the legal regime of investment law. Thank you very much for your listening. So if you have a question or if some points are not clear, please don't hesitate to ask questions, please.
Let's give him with flowers again, please. Okay, we go with the questions. So many questions for you.
Thank you so much for the insightful presentation. So mine relates to the choice of forum between state parties in an event that there's a dispute. You mentioned ICSID as one of the forums that state parties can exercise in an event of an investment dispute. And then we also have dispute resolution mechanisms under the AFTA. So I wanted to know, because this is very important, because we as lawyers, we know, or rather we are alive to the fact that forum goes to the jurisdiction of the matter. So my question is do the two pieces of legislations allow state parties to exercise option on which forum to use to determine their dispute? And the reason why I'm asking this is that we as Africans have a tendency of frowning upon the legal systems in Africa. So mostly investors would rather submit their disputes to ICSID. So what else is being done to ensure that we have institutional confidence in the systems that we are creating? I submit. Thank you.
Thank you, Prof. And thank you so much for that enlightening presentation, and also shining a light on some of the protocol's limitations. My comment is similar to Mr. Kangwa's comment, and that is that ordinarily or ideally, investors will invest in an economy or jurisdiction where they know that if a dispute arose, the dispute will be resolved efficiently, effectively, competently, and of course with some level of predictability. So we know, I think in the profession, that most investors do not prefer to bring commercial disputes, certain commercial disputes rather, to national courts. And I think this is the only option which the protocol gives, apart from choosing to use a dispute resolution procedure under the AFTA. But there are certain disputes, for example, trade secrets, which an investor would not want to bring to the national courts for obvious reasons, because once that dispute is brought to the national courts, then the secret is no longer a secret. National courts registries are usually public. So I think it's very concerning that we have a protocol that seeks to promote investment, but does not have provisions, ideally, that provide for dispute resolution mechanisms such as mediation, which are confidential, and arbitration, which are also confidential to a large extent. So I thought that's a very serious omission. Thanks.
Okay.
Thank you. Thank you for the presentation. So I just wanted to broaden this conversation, since we are thinking about investment. There is a concept on political insurance, and some of the examples that I've seen is political insurance is given by development partners like IMF and World Bank. So I don't know if there is a possibility to decentralize this and have this at local level, because I don't think most investors have access to World Bank and IMF. So is there a possibility that we can have this at lower levels?
Thank you. Two issues to deal with. First issue is dispute settlement, and the second issue is insurance issues. Let's start by the first issue. You should understand the perspective of the investor. When an investor comes to a country, he has the right to be protected. If you, for example, where are you from? From Kenya. You will go to China to invest. Then they will say, if you have a dispute with China, we will go to the Chinese court. What is your feeling? Do you feel comfortable or not? So you have to understand that the investor, when he comes to a country, he has the legitimate right to be protected. That's why investors today requires the use of arbitration to settle their disputes. The problem is that all the African treaties that were concluded between African and non-African provides for arbitration. We find ICSID arbitration, ICC arbitration, ad hoc arbitration. So for the French, the English, the American, if they have a problem, a dispute with an African country, they can use arbitration. Just to clarify that ICSID arbitration is a mixed arbitration. ICSID arbitration is used to settle a dispute between state and foreign investor. ICSID arbitration could not be used to settle state-to-state disputes. So the bilateral investment treaties that are into force, concluded by all the AFTA members, give the non-African the right to go before ICSID and other system of arbitration. Now, let's move to the African investors. They are few. You can give them the right to go to arbitration. They are few, and they told you they don't use arbitration, Africans. We have 6 cases between an African investors and an African state. So for Africans, they said, no, we cannot give them arbitration. We will see what is the mechanism that could be negotiated. So they did not take a decision on dispute settlement. That means that the only option is the court, the state court. So if you invest in an African country, you need to go before the state court. And you know, the state court, there is a big risk. I don't want to mention countries here to be politically correct, but I close this chapter. The second issue, the second option is to use the state-to-state mechanism. You should go convince your state, because you don't have the right, the direct right. You have, if you are an investor from Morocco, you have to go to the Moroccan government and ask your government, please help me use the African dispute settlement mechanism. That is, I will show you tomorrow, it's a state-to-state mechanism. Then the Moroccan state will think about it. I will use or not. And if the Moroccan state uses the system, the investor is excluded, because the mechanism, and I will show that to you tomorrow, is a state-to-state mechanism. So why you give non-African the right to go before arbitration, and for the African you prohibit, you limit their right? In addition to that, more seriously, the old intra-African investment treaties provides for arbitration. If you look at the treaties between Tanzania and South Africa, or South Africa, Tunisia, and Nigeria or Niger, all of them, they provide arbitration. Now they said, no, with the protocol, we have to terminate them in 5 years. So that's unbelievable. We terminate the old treaties and we replace them by a system is less protective and discriminate African compared to non-African. That's a fabulous system. And we are supposed to be with African, working together, sharing the same value. As I told you, there is a disconnection between the legal reality and the political objectives. The protocol includes a list of objectives. When you read it, you feel very happy. You say, oh my God, this is African United, African promotion of investment. Objectives are solidarity, cooperation, collaboration, friendship, brothership. I don't know what's the meaning of those concepts. Then when you look at the rules, you see, I have the feeling that there are two people that drafted the agreement. The objective was drafted by a person, and the rules are drafted by another person. And they are in dispute. They don't have the same conception. Regarding to the insurance, as you know, many investors in Africa, because of the risk they conclude insurance contract with mega multilateral international guarantee agreement within the World Bank. Some of them, they get insurance from their own countries. In many countries, we have a system of insurance of the investor when they invest abroad. All the insurance contract provides for an arbitration. So if the company give you the guarantee, normally you have in the contract an arbitration system. So the insurance company provides for arbitration. If there is a problem related to the insurance contract, arbitration could be used. So, is there any other last issue? Yes, please. No problem. I will. The lunch will be postponed. It's a unilateral decision, and there is no arbitration. You understand now the arbitrary of the system. That's all.
Yes.
Yeah. Yes, please.
Oh, sorry.
Quickly, but
I have
please.
one question.
A question, not a comment. Question. Short question. You are here not to make a speech. Yeah, please.
We see under the interpretation of what amounts to investment, they made mention of sustainable development as one of the characteristics of an investment. And also under part 5, we saw a whole chapter dealing with sustainable development. And moving forward, we also saw, yes, the protocol making an obligation that states must regulate in regards to that. I want to know, how would states balance the protection of investors, especially foreign direct investors, and sustainable development? That's one.
I don't know. It's a very difficult notion.
In your opinion?
What is development? And what is sustainable development? And the sustainable development for Morocco is not the sustainable development of Kenya. It's not clear. It could be a subjective notion that is used by the state to exclude the protection. What is this? I understand there is a debate today on that. Development, sustainable, progressive development, cultural development, economic development, political development. I don't know. And we don't have a system of dispute settlement, at least to explain. So you come to a state, you invest, then the state tell you, no, it's not good for us. It's against our development. And who determines? The state? Or it's an objective notion that could be controlled? Who determines? Even if there is a notion, even if we find a conception of sustainable development, we can. If the investment creates, for example, 100 jobs, if the investor pay 10% of taxes, you can find some criteria to determine it. But then, who determines? Who determines? So, I know that this notion is included in many treaties, but I have to draw your attention that the interpretation of this notion is very, very, very difficult. It's very, very difficult.
Okay.
Another question?
Yes, I'm not done yet. I just want to draw your attention to Article 46.
Yeah.
Because I found out that we have like two separate forms of dispute settlement. The first one in Article 44 deals with state and state, which is governed by the dispute settlement protocol. And the one in Article 46 deals with state and investor-state dispute. Yes.
Mediation.
And also, but I think it is my opinion that we still have a chance to make this happen, just like what you are saying, because it makes reference to annex, that an annex governing, providing rules and procedures for investor-state dispute settlement shall be concluded within 1 year.
Yeah, 1 year.
I think there is still room for a dispute settlement mechanism.
My conception,
Yes.
you should think about the dispute settlement, then we should negotiate the rights, because the most important element, you know that if you have treaties without control, we don't need them. What is important is control, enforcement. If you don't have a system of enforcement, all of them, they are worthless. So there is a mediation, yes, but mediation, it's not a binding mechanism. We negotiate 1 year, 2 year, 3 year, we negotiate. Then we pray. If you have a God, you pray. If you don't have, you stay in your place and you hope change of the government. So that's unbelievable. We take 5 years to negotiate this agreement, this protocol. Then, for the dispute settlement, we were enabled. We said we will do it next time. And we have to wait the 22 ratification. Then you have 1 year. And you know, like me, you think that they will succeed to negotiate a dispute settlement within 1 year? They are working on it for 6 years now. And they were enabled to find an agreement on the dispute settlement. So this is the African method to settle the problems. If there is no solution, let's do it later. They took 5 years. They were enabled to find an agreement on the dispute settlement. What do they say? We will do it 1 year when the agreement will be into force. 1 year. My God, you have to be realistic. I don't know how they will find an agreement on that.
Can I intervene?
Yeah.
Maybe I need to set the record straight. Investment was part of the phase 2 protocols. As I had said earlier, there was a rush. We were rushed to have to conclude this. You must understand this particular protocol and the IPR one and the competition were negotiated within 2 months. 2 months. Now, what drove some of these provisions was the experiences within the continent in terms of investment and the existing BITs, and some of them having provisions that were not necessarily good for the continent, including the sunset clauses that are there, even as you've seen in the current protocol, the current agreement with Tanzania. So the idea was to come up with something negotiated. The text there was negotiated according to the views of the people in the room, the negotiators of the different countries. So to say it was negotiated within 5 years, that is not correct. And secondly, and that is why there was a provision to have to conclude now the detail of the the dispute settlement later on, having considered all those things. But the rush made this kind of instrument. Yes, it's good to take cognizance of the fact that it may not necessarily be good for the continent, but you must understand that even the previous BITs that existed were not necessarily good. South Africa, for instance, had to revoke all the agreements. Kenya has had to revise our investment policy, and we are also reviewing all the BITs that we had to cure some of these things. So I think it's fair to say it's a work in progress. It is not concluded yet, and it's not implementable yet. So give it time.
I understand, but the problems of Africans is not because of the African investment. It's because non-African investment. The problems that many African countries faces is not because African. It's because investor from non-Africans, from US, from England, from France. As I told you, African and non-African, we don't have a lot of problem. So if you want to deal with this issue that I understand, you have to face investment treaties between African and non-African. So the problem I understand, but the solution is not linked to the problem. Because they have a problem, I know that they have a problem. Second, this agreement take into consideration many other instruments like the African Investment Code. So the idea was very old. And there are many people that were working on this issue for many years. So I understand that the period was very limited. And the not the order, the suggestion was to conclude it as soon as possible. But if you want to deal with the African problem with investment, go to US, go to France, and try to terminate the investment treaties with them. But if you have a problem with a French investor and you terminate your treaty with Tunisia, I don't understand what is the link. Any other question?
Yes.
Prof, the people in the kitchen are saying that they want to go. So please, people asking questions, ask questions straight, like Prof said. What, why, straight. And
If not,
Prof,
I will
answer
leave.
them briefly also.
If not, I will leave.
Go.
Okay. So one of the things that I picked out from your presentation is the fact that there is limited intra-African investment, and so the application of the protocol in itself is limited. So my question is, beyond the protection standards in the protocol, does it include any proactive facilitation mechanisms, say capacity building or investment promotion, any other investment promotion mechanism that is designed to boost intra-African investment? And if there is, how is that obligation structured?
Yes. The answer is yes. There are many obligations regarding facilitation. However, all of them are best effort obligation and within the domestic law. So they are not hard obligations. They must do their best effort too. They must use all the reasonable means to promote. So we have this kind of soft obligation, but they are not hard. To be honest with you, yes, the protocol includes a chapter on facilitation. However, the obligations are best effort. Do what they can to facilitate. Sometimes it's very difficult to understand how to determine the scope and how to determine if the obligation was observed or not. That means that, sorry for the comparison, a country like, I don't know, Nigeria and a country like Tunisia, maybe they don't have the same means. So if you see the obligation could be applicable for Nigeria in a different way than in Tunisia. So this obligation do their best. What does it mean, do their best? We have to take into consideration the legal resources of the state, the means of the state, so it's not easy, but we have a list. We have a list of new measures related to facilitation, that already exist in the national investment codes. Many of them exist. And I can add that we have here a protocol, but each state can adopt its investment code, and the state can give the investor more obligation, more rights than the African protocol. And many states, they want to do it because you have to understand that there is a competition between African states. And some of them, they don't want to have the same legal regime on investment. The conception, the politics is not the same. Morocco has a politic related to investment that is not the politic of Libya. So some of them, they don't want this harmonization. And in their domestic law, we can find provision, obligation, arbitration. So my opinion, if I was consulted, I propose to negotiate a minimum, and you authorize the state that want to go more to protect African investment to go further in their domestic laws, for example, or by concluding treaties together. That could be a good compromise. Yes, last issue, because I am tired. Yes.
We have concluded now. Yeah, she will
Thank you.
conclude. Yeah.
Thank you for
Thank you very
permitting
much.
us to.
Please give him his flowers.